This is Paul Turner, the Immigration Barrister at Imperium Chambers. If you have an immigration problem or any immigration query, please get in touch with me and I'll do my best to help you. Today I'm going to be talking about a new law that significantly extends possibilities for becoming a British citizen through one of your grandparents. After recent changes made to the nationality law in the last couple of weeks, there's been the addition of a new section, Section 4L, which opens up the possibility for securing British citizenship through UK ancestry. If you have any questions or think that you might qualify under these new changes, and they are quite complicated, then do get in touch with me and I'll do my best to help you with this, as I've mentioned, on any other immigration issue. The new law itself is contained within Section 4L of the British Nationality Act 1981 and came into force on the 28th of June 2022. At the same time, the government published the application forms and the relevant guidance. It is vital, I think, in this particular case, for me to read the actual section out. I'm loath to read out law because it's not that interesting, but I think so here. Subsection 1 says that if an application is made by an applicant of full age and capacity to be registered as a British citizen, the Secretary of State may cause the applicant to be registered as a citizen if, in the Secretary of State's opinion, the applicant would have been able to become a British citizen but for historical legislative injustice, unfairness, an act of omission of a public authority, or exceptional circumstances relating to the applicant. Subsection 2. For the purposes of subsection 1a, historical legislative unfairness includes circumstances where the applicant would have become or would not have been ceased to be a British subject, citizen of the United Kingdom, or a British citizen if an Act of Parliament or subordinate legislation had, for the purposes of determining a person's nationality, treated males and females equally, treated children of unmarried couples in the same way as children of married couples, or treated children where the mother was married to somebody other than the natural father in the same way as children where the mother was married to the natural father. Subsection 3, 1b, public authority means any public authority within the meaning of Section 6 of the Human Rights Act 1998, other than courts or tribunal. And subsection 4 says, in considering whether to grant an application under this section, the Secretary of State may take into account whether the appellant is of good character. The general question, turning away from the law, is why was there a need to introduce this section? Previously, there were sections in the 1981 Act dealing with historical legislative unfairness. These tackled, they now tackle the present day effects of past discrimination against women or illegitimate children. Section 4C says that anyone born before the 1st of January 1983 has the right to register as British if they would have been a British citizen had their mother been able to pass on the nationality in the same way as a man. Sections 4E to 4J gave people the right to register if they would have been or could have become a British citizen had their natural father been married to the mother at the time of their birth. However, there are some gaps in these provisions. The only remedy discrimination in respect of discrimination is it affected citizenship transmission from a parent. So there is no remedy in the present day law for discrimination in the grandparental generation or higher, so it only relates to your parents. They do not work for claims based on a connection to a British overseas territory. This is, however, addressed in a new section, 17A to G. They cannot be applied cumulatively. In other words, you can't remedy the combined effects of different types of discrimination on the same family history. As we shall see, the new legislation is particularly significant for people with British grandparents. Section 4L also expands on unfairness as potentially including any legislation which discriminates on the basis of protected characteristics such as age, disability, gender realignment, marriage, civil partnership, pregnancy and maternity, race, religion or belief, sex or sexual orientation, which brings it in line with the Equalities Act. The guidance refers to the possibility of applying for citizenship through grandparents in the following terms. In terms of people with British grandparents, Parliament's intention was that citizenship will only be passed on for one generation born overseas, and Section 4L is not intended to change that, although you must consider each case on its merits and assess if there are exceptional circumstances. So that's really important. It's true that double descent, passing on British citizenship to the second generation born outside British territory, is not the normal course of events. But it was and is possible that the guidance tells us to set out the legislation and say why you think it was unfair. So there is the possibility, but it won't be very helpful for those that aren't legally unrepresented, given that this is complex. A classic example of unfair legislation which was corrected in the same act related to the Shigosian community, who were evicted from their homes by the British government, and were not, by virtue of the British government's actions, to pass on their nationality. This illegality, unfairness, has however been corrected in the new Immigration Act. I will go through, just to flesh this out, a few different scenarios that can be related to people's cases to see whether they have a prospect of success. The first example, and I will call it example A, is A's paternal grandmother was born in the UK. A's other grandparents and parents were born before 1949 in Trinidad, and A was born in Trinidad between 1949 and 1962. In this example, A acquired citizenship of the United Kingdom and colonies by birth of being born in a colony, but would have lost it when Trinidad and Tobago became independent on the 31st of August 1962. The Trinidad and Tobago Independence Act 1962, which was the UK law dealing with independence, contained historical legislative unfairness. Section 2(3) of that Act provided for Trinidadians to retain their UK citizenship if they, their father or their father's father was born, registered or naturalised in the UK or a remaining colony. The status of A's grandmother as a person born in the UK didn't help. So if the grandfather was born in the UK, you got it. If your grandmother was born in the UK, you didn't get it. If in the same scenario A's paternal grandfather had been born in the United Kingdom, A, as I've just mentioned, would be a British citizen and today. This type of discrimination was a feature of all independence legislation in the 1949 to 1982 period. Example B, and I'll refer to him as B, B's paternal grandfather, who I will call G, was born in the UK. While stationed abroad as a British Army officer between 1949 and 1982, G had a son, B's father, who was born out of wedlock. G was never married to the mother, B's paternal grandmother. He retired to the UK and has now died. Both of B's parents were born in the UK. B himself was born outside the UK after 1983. So B's father was born illegitimate, as nationality law put it at the time. Therefore B's father never acquired British citizenship. G, although his natural father was never regarded as his legal father under section 32(2) of the British Nationality Act 1948. If B's paternal grandparents had been married at the time of B's father's birth, then B would have become a British citizen. On commencement of the 1981 Act, B's father would have become British under section 14 subsection 2 as a British citizen, otherwise by descent. This is because G was in overseas Crown service at the time of his son's birth, having been recruited, this is assumed as for military purposes, and B would have become a British citizen, as I've mentioned, at birth. In essence, Section 4L opens up significant possibilities for claiming British citizenship, including those born in a foreign country before 1988 with a UK-born grandmother, amongst many other cases. This is not entirely apparent from the Home Office guidance, which asks people applying for citizenship on the basis of historical discrimination to set out the specific legal provisions on which they rely, and as if you listen to this video, it's complicated. As the examples I've shown, those with UK-born grandparents may well have strongly arguable claims for British citizenship, but it is important, given the way that the Home Office has structured this new law, that they get proper legal advice in respect of whether they can claim it. And it's also because simply just asserting it will just not be good enough. It will be necessary to point to the relevant legislation. And as you will have recalled, if you've managed to stay awake during this video, some of the legislation relates back to the British Nationality Act of 1948. Others refers to the various independence acts granted to former colonies from around 1962. And then we have the British Nationality Act of 1981. So it's a true maze that people have to navigate through. But what it seeks to do is to get rid of the discrimination based upon illegitimacy, also to get rid of the discrimination based upon whether you're a man or a woman, such as if your grandfather was born in the United Kingdom, then you would qualify, but if your grandmother was born in the United Kingdom previously, you wouldn't have qualified. So there are a number of hopeful ways forward for people to essentially become British by virtue of UK ancestry. So I hope you followed this video. It is quite a complicated area of law. In short, what I would say is that the new law opens up the possibility for correcting historical injustice, looking at whether the Home Office or a public authority has treated you properly. And it also says that the Home Office has got to consider things on a case-by-case basis and must look at exceptional circumstances, which again is a reason to see a lawyer. I hope this video on what is potentially a very wide-ranging reform which is in applicants' favour has been of some interest. In essence, if you have a grandparent that was born either in or outside the United Kingdom, or your grandparents or parents were or were not married, then the law may well have changed in your favour, and it is well worth getting an opinion either from me or from a reputable lawyer to see whether you qualify under the immigration rules in UK ancestry for British citizenship. So it's a good piece of news, but it's a very complicated one, as is the case with most nationality law. Thank you very much for watching this video. As I say, do get in touch with me if you are confused about it. It's taken me a while to get my head around it myself, and I'll do my best to help you. Otherwise, do stay safe. Please subscribe to my channel. Thank you again for watching. This is Paul Turner, the Immigration Barrister at Imperium Chambers.